Prohibition is quite easy to understand. It means forbidding something. A writ of prohibition is issued by a higher court to a lower court or a tribunal to prevent it from exceeding its jurisdiction or acting without jurisdiction, or if the law is not being followed properly. For example, a writ of prohibition can be issued if a magistrate's court is trying a case that should be tried in a sessions court, or a civil court is trying a criminal case, or a tribunal is trying a case without giving the parties a fair hearing, or a lower court is acting under a law that has been declared unconstitutional, or a court's actions are in violation of the principles of natural justice, or a court's actions are in contravention of fundamental rights. These examples are based on several landmark cases where the courts have clarified on the scope of writ of prohibition and its applicability in various situations. For example, the writ of prohibition can be issued against any judicial or quasi-judicial authority. The writ can be issued even if the proceedings before the lower authority are still in progress. The writ can not only be issued when fundamental rights are actually violated, but also when there is a threat of violation. Now, remember these two statements. Prohibition is preventive. Certiorari is corrective. Easy to remember because P, C, C. Now, prohibition is preventive because it is issued before the order is passed by the lower court to prevent the decision or the order from being passed. What happens if the order is already passed? That is where the writ of certiorari will come in, which is used to correct a decision or an order that has already been passed.